Professor Robert Walters. So, Robert, the floor is yours, please.
Hey, Professor Novak, appreciate the introduction there, and welcome everybody. I'd like to introduce Emeritus Professor Leon Trakman, who's a personal friend of mine, and we've been working together now in transnational commercial law and data protection and cybersecurity for the last 6 years. Professor Trachman has a substantial history. He's the former Dean of the University of New South Wales in Sydney, Australia. That's a top 10, 15 university in the world. And he's also an international arbitrator and barrister. And so thank you, Leon, for giving up your time on a Friday evening back in Sydney, Australia. Welcome to Slovenia, even though it is via this forum, and we welcome you and look forward to hearing your presentation. And just on that point, Leon and I have authored 2 books together. One on data protection law and the other in transnational commercial law. So over to you, Leon.
Thank you very much. Can you see me?
Yeah.
Okay, good. Look, what I'm going to do, and following Rob's kind introduction, is just to give you a view on, before I begin, on some of the issues from a rather emotive perspective. The world that I began as a young boy had nothing that we see today. What we're doing now is inconceivable. It was. And even for my father, who lived until a few years ago and remained mentally capacitated until fairly late. Sorry? Rocking. Okay, sorry, I'm rocking in the chair, she said. Basically, could not go beyond the early stages. The truth of it is, what we have now is mass communication. We rely on the internet, not simply as an instrument of retrieval, but as the very essence of our communication. They say even after the pandemic, we have initiated changes that will lead to a change in the workplace significantly for many of us, because we can do as well working at a distance then together in a place or single place. We've also lost a certain amount of our protective shelves. We historically were able to maintain a certain amount of privacy, if you want, to use a traditional word that we use in both common and civil law, which in effect we have increasingly lost. We're now subject to mass exposure, our personal identities, our personal information, banking details, healthcare, etc., all of which is available. And the book that Rob and I produced a few years ago, which I suppose in some ways is already massive advances in technology, those developments indicate that we can be victimized. There's lots of stalking, but it also goes to the very essence of the business community, where we have invasions of people's personal information, which can impact upon the survival and sufficiency of a business enterprise. So it's personal in the sense that personal data is very much in essence, but on the other hand, it also can affect the broader dynamics, directors, shareholders, creditors, etc., that are associated with commercial activities. The contrasting view, and this is an area I'm currently working on quite extensively, is the model of freedom of expression, freedom of speech, freedom of association, which is a predominant model in many constitutional jurisdictions, particularly in North America and to some extent in Canada. And I'm a Canadian, and I was involved in the Constitution with some regret on this issue. The result has been, to some extent, that there's a tension between the notion of the free market in ideas, the freedom to express your views in an open forum, offline and online, the ability to talk about information that you have, that you know, within the realms of avoiding defamation and libel. And on the other hand, the notion that there has to be some element of constraint, some uniform measure that protects you comparably to the way it protects somebody elsewhere, given the fact that the New World Order recognizes no boundaries. We are living in a borderless global order from the point of view of being able to communicate across borders. So in a sense, national law, which remains important, and we'll talk about it, is essentially in some ways outmoded, because effectively you can avoid the impact of a domestic legal system and a domestic jurisdiction if you're talking in cyberspace, as we are in fact at this moment. So I'm going to call up the PowerPoint, and if I can find it, here we have it. And then I'm going to perhaps talk from that. Okay, and I just need, can you see it? I could probably just, can I do the...
Yeah, we can see it, but it's not in presentation mode.
Okay, let me just put it in presentation mode. Presentation mode is, where do I see presentation mode? Pardon? Where? Oh, sorry, from the beginning.
I think
Sorry.
we just click from the beginning.
Okay,
Yes.
I have it now, okay.
No,
And there you've got the regulating data flow in a digital economy, and there's the ideological issues, which I've mentioned, the tension between the free marketplace in ideas and the notion of privacy, data privacy, protection of your personal information, and then the issues of diverse legal systems, how different legal systems regulate sometimes extensively and sometimes limitedly invasions of one's personal data, and then the functional diversity that we have as a practical measure across jurisdictions, within jurisdictions, around our own capacity to keep our information private, the ability to share it, who in fact can access our information, how can they take advantage of our limited ability, how we can protect ourselves both legally and, of course, in a functional way. For example, maintaining security on our modes of communication, particularly online. We talk about it as the fourth industrial revolution. We can debate about that. Essentially, we are now in a post-industrial revolution, and I think the pandemic has made that all the more acute. We have constant advances, as we said, in AI and the internet. The scope of collection of data, the cloud and beyond, now allows us to accumulate enormous amounts of information without limits. In effect, you can pay a little bit more, you can get more cloud, but the amount of cloud you get is a great deal more than any hard drive could conceivably imagine 5 years ago. And 10 years ago, it's massively different. So there is more public access to our data. And again, we have more access to other people's data, although we're not in effect data processors and controllers in a commercial sense, in that most of us are simply users, but we do have access to other people's personal information very often. And particularly important is the scope for trade in personal data. The fact is, your data is worth money. It's worth money to Facebook, it's worth money to Google, it's worth money simply by virtue of numbers. The number of people that use become attractive for advertisers who want to advertise on these web spaces, so they can attract large audiences, so numbers matter. And of course, data itself, personal data, can be sold. And you may have heard of a number of scandals. The common one is the Cambridge Analytica one, where there was an exposure of information collected about people, which was used for the purpose of electoral, in effect, fraud, a corrupt process, which was essentially resolved by the dissolution of Cambridge Analytica, and they bought their data or acquired their data from a large entity called Facebook. So the result is, the fear factor is, who collects your data, who processes your personal data, and where does your data get circulated? Or in effect, where does your data get accumulated as well? So it's an accumulation of data that often gets circulated. How personal is your data? Is it your age, etc.? Is it your name? Is it your identity? Or does it go beyond that? Does it go to some scandal affecting your job? Does it go to areas where you could be stalked? Does it identify anything around your health, your care, your social involvements, your friends? So it is capable of being transmitted, and the greater technologies that are available makes it ever more widely capable of circulation and impacting. And I've mentioned to you what cloud computing can mean and has meant as it grows in importance. As far as COVID's concerned, we all know that it's had a massive impact, but we won't really know the full impact. There are theories around how many people will not return to the workplace environment. There are a lot of cities that are reducing their office space because they're relying on people to work at home. And effectively, people are engaging far more online, which means more people, which means more data, which means more usage online, more personal information, more opportunity to circulate, more opportunity to become victims or victimize others through the misuse and the abuse of that data. So what we have is, I wouldn't say a deceleration of face-to-face, but we certainly have a massive acceleration of online communication. We have better technologies, we have more online use, we have more use prospectively, we have a greater degree of emphasis on protection. And I can tell you about something I just heard this evening around what was happening. A lot of people are being they take their faces, this is in Australia, but I believe it's happening, and they use it to advertise products. And there's some very prominent people who are clearly identified as being significant in the sector, who have discovered their faces being used in advertising. They even have a way of getting them to be saying things they're not saying, which supports a product that is being advertised. That's the extent to which they can abuse you as a person, in effect simulate your identity for the purposes of their marketing and abuse. And very often, these are not little guys out there, the typical cyber squatters, but highly sophisticated players who have a significant market presence. That's the extent of the potential abuse. The issues around government, how do government regulate, and again, the issues we discussed at the outset, rather I discussed, this is a bit of a soliloquy, that is the fact that there's zero regulation in some jurisdictions, partly because of limited sophistication and understanding of the technologies, and sometimes because high emphasis is on free exchange of ideas, particularly where there's foreign financial backing. And in fact, we have countries that are dependent on the large corps and do not want to be seen to be regulating their flow of data for domestic interests. But that effectively does mean massive disparity in the regulation of the use of data and in the potential abuse of personal data. So effectively at this point, and again, I don't really need to say some of this because it is profoundly logical, we have more and more personal data that is subject to review. We have it asymmetrically exploited. There are highly sophisticated cyber squatters. My children who are in their 20s and 30s already, I find, are out of date. They're youngsters, 18, 19, 20, who have more adeptness. My youngest, who's 27, would actually be able to write programs for computers, but he himself says that people, the next generation, are getting that much better. So we have younger and younger people who have higher degrees of cyber invasiveness, but nevertheless, targets can be other children who don't have that, the elderly. There are clearly vulnerable sectors in society that can be significantly harmed because they're more effectively exposed to the abuse and are not as well able to protect themselves. And incidentally, these issues around these large corporate players who were, I found out today, the subject of essentially misused identity, themselves did not detect the abuse. And they say, for example, the use of the new currencies that we have, online currencies, is a classic example where the abuses have gone into hundreds of millions of dollars on a daily basis. That's how severe cryptocurrency abuse can be in terms of manipulating information, including effectively stealing people's identity for the purpose of advertising. So essentially, there are orchestrated cyber attacks that are organized by large, significantly capable and sophisticated players, but there are also very sophisticated players there who do not have the large institutional backing, but are very good at cyber hacking and abusing personal information and data. So essentially, the potential for exploitation is greater, but one thing I haven't mentioned particularly is the extent of profit, that you can really make a great deal of profit. One gentleman I was interviewed online had in one day lost $99 million. That is how much, and this is not an unsophisticated player. This is someone who really believed that the cryptocurrency transactions he was engaging were legitimate. That's how convincing it was. So the exploitation potential is enormous. And we also know that mega corporations, some of the largest in the world participate in this. They make their revenues out of accumulating data. They sell the data for the purpose of making further returns. That is a reality of the world we live in. So the issue of how do we address the abuses is what we effectively face at this point. Crime very often and abuse very often way precedes regulatory responses, and we have that very significantly in this particular sector. There's so much growth in the defrauding and the stealing of personal information, the collection, processing, and circulation of that information, that the regulatory systems are not able to keep up with it, and very often don't, and very often don't want to, because they're afraid of alienating corporate players who are effectively dependent on the free flow of data. So there's a lot of difficulties around people not disclosing the information. If I'm the subject of abuse, I know a number of people that are. You very often keep it to yourself because it's a personal failing. You don't want to expose yourself to more abuse. A lot of the online dating abuses, stalking, involve people that do not want to talk about it because they're afraid that they will encourage it rather than discourage it and facilitate further abuse, or they want to simply remain private. That's not a new psychological reaction. Victims of rape, for example, sexual assault, which is an area that my wife works in, is largely an area that there's very limited detection because there's very limited disclosure. And that is really the issue. We don't really know how much access to personal information there is because it's not disclosed by the abuser. And very often, even if you know your information is being abused, a lot of people will not disclose it for those, among other reasons. The other one, of course, is you don't want to be seen as a failure, as having exposed yourself, as demonstrating that you were fooled, cheated, or confused by a cyber attack or a cyber bully or some form of cyber espionage. So the issue around the costs of cyber breach, we don't really know how they are. My personal view is they are very high and much higher than we are aware of for the precise reason of limited reporting and limited assessment. We also don't know how deep it goes in the sense of what the impact is, psychological damage, financial damage, and sequelae. People live in families. If there are mental health issues, that does impact. If there are financial consequences, that also has further impact. So those are some of the difficulties in detecting and accumulating information on data abuse, data collection, data processing, data use and data sale, all together being perfectly legitimate if they're properly used, but very questionable and very harmful if they're not. In terms of the regulatory arm, which is an understandable problem, but one that has not been adequately addressed in Rob and my view, and I think Marco's, Professor Novak's view probably as well, because we've written on common areas, is there's massive inconsistency and inequity in the regulation of personal data. That is across boundaries, i.e. different states, different regulatory frameworks, but also in the form of the squeaky wheel, People with influence may do far better in protecting their identities than many others. People that have the skill and sophistication to detect may be better than others. And that's often what we refer to when we talk about targeting, how cyber attacks very often are targeted. And I'm not talking about high-level espionage, but essentially trying to get access to your bank records, etc. These very often target vulnerable sectors, which could be vulnerable by virtue of limited education, by virtue of limited technical capability, and by virtue of limited resourcing. You can't fight back if you don't have a resource base. The issue around harmonization, and again, this is a debate that Rob and I have had very often. We're both idealistic and we'd like to believe that we can come up with global solutions. The truth of it is idealistic. The idea that we'd have one solution to fit all isn't realistic in the sense that, for example, the United States is deeply preoccupied with the 14th Amendment around freedom of expression, freedom of speech. They have significant, strong emphasis on the free flow of data, freedom of the press. That is a fixation, very hard to address from a point of view of subjugating, controlling the free flow of information. The EU, on the other hand, with its GDPR, its General Data Protection Regulatory Framework, on the other hand, is far more engaged in data protection. And in fact, the GDPR has precisely that goal in mind. And what I'm currently working on, in fact, is a comparative study between the two, which is quite fascinating because even though there's a lot of agreement in the public domain, it's very often in the areas of the powerful and the elite that there's less willingness to change from those traditional ideologies. The US, the individual autonomy, freedom of speech expression, and the European, a greater sense of social justice, more emphasis on protecting your private life, your privacy if you want. So that is part of the problem. These are ideological, political, and economic ideologies, and that's, I think, the essence of the US-EU preoccupation. There's also great variations in technological development from one to another environment. Within, we know there are poor and rich people everywhere, technically advanced or not, but there are countries that lack the technological capability to seriously control and constrain the abuse. And Rob has actually been working on a giant project in that regard, which in fact looks at issues around degree of regulatory governance that different jurisdictions, different states can muster. And there's great disproportions in what they can do and have done to essentially arrive at a regulatory framework for data protection, let alone a uniform framework, or let alone an advanced framework. So those are additional problems. The further one that I should mention, and I don't want to speak too long, is the issue of data localization. And I'd like to talk a bit about that separately because I think it is an important topic. And also the, I don't want to overemphasize the pandemic. It's becoming a story unto itself, but it is clearly very relevant where we currently sit with the instability in the international order, personal, economic, social, and political. So data localization, which I think is becoming important, is that it allows individual states more control on how their citizens' data is used, collected, stored, processed, sold, etc. Some countries pride themselves on data localization and the protections, and I believe the EU has in fact done rather well in that area relative to other jurisdictions. There are flaws in everything, and the EU would have its own flaws, but the truth of it is there has been a greater recognition of the potential abuse of localization, which is something the EU is attempting to regulate, particularly with non-EU sources that abuse, and also regulations that constrain the abuse of data within the EU. The contrast is localization does have certain risks, and that is it is effectively the protection or not of data within a particular local domain. So the issue is, how do you ensure that there is a level of protection, if not harmonized everywhere, which we'll never see, that there's a level of protection that provides a common denominator between the EU, the US, Africa, where I was born, proud to say, Europe, Asia. How do you have some minimal, consistent level of data protection that reflects the autonomy of an individual over their personal information, that identifies that there's certain data frameworks that are more sensitive than others, such as your health record, your bank statements and other such things. And there's also, that's in the private domain, a massive issue around cyber espionage, and that is the abuse of public data that are essentially regarded as part of national security. And we all remember instances of databases of government, highly protected databases that have been exposed to data abuse. In fact, it must have been 20 years ago, the young Princeton student was able to access the US security database. He was just very smart, and he got in, and this was regarded as the ultimate vault of vaults to protect data, and he got in, and he was able to access the information. And he was, a kid in university like we are, and he was able effectively to expose the vault of information. In terms of legal divergence, how do you address it? And I think that is an issue. A couple of things to emphasize is discriminatory protection. In some jurisdictions, I'm a wealthy data collector and processor. I will look for those data environments where I can operate successfully, set up offices, whatever, if I believe or feel that the data laws will give me that leeway, or alternatively, that I can have them constructed, or I can manipulate them in such a way that I can continue to function there. So that is an example of an opportunity to essentially allow data abuse to occur discriminatorily because of different regimes and different degrees of tolerance of data abuse. The issue of uniformity, I think we have to submerge that into more practicable possibilities, and one is best practices, i.e. no perfect one solution that everyone can expect to adopt. The Americans are never going to adopt the EU framework, and the EU is not going to adopt the American framework. Even though the train will not meet, there may be opportunities for collaboration. At the best we can hope for is that we will find best practices upon which we can agree, i.e. how can you protect data in certain common denominator situations? What are the best practices by which to do so? And I think that is a realistic framework, what we often refer to as a data adequacy framework, which is increasingly emphasized now because it seems to be the only really viable solution structurally in the absence of uniform data regulation. So what we want is not perfection, but I think the words here, cohesion, efficiency, and some degree of equality in regulating cross-border data flows. And ideally, we want to do it collaboratively, i.e., I'm not saying we'll have a United Nations that deals with data protection, but we would conceivably have specialized organizations, regional, local, regional, and international, that would effectively assume responsibility for regulating data, the use and the abuse of personal data. What you need for these purposes is, I don't like the word harmonize, I've become disenchanted with it, but most of the rest is what I would emphasize. We need global support for uniform law. We do have that to some extent in international organizations, of which the UNIDROIT, the UNCITRAL, or that's how you pronounce that, are all areas of activity. The Commission, Uniform Commission on International Trade Law, Conference on trade and development. These are all entities, and beyond those, regional organizations, we mentioned some like the EU, that are actually supporting collaborative regulatory reform, which means you have to establish policies, you need to have principles by which you implement those policies, you need to have standards of comparison by which you work out how effective best practices will be in different settings based on the policies and principles and how they're used, and you need to have rules of operation. So it's not a simple case of saying, well, we all agree that we shouldn't allow data abuse. We all agree as a matter of policy that data abuse that undermines a person's personal sense of self-worth is bad. That's all very well and good, but we need to have a more piecemeal approach to how we go about achieving those results in particular situations. And I think that's the key. How do we move from the level of policy through principles and standards to application? And I think that is the major challenge for public entities responsible and private entities through their own internal regulatory systems to arrive at not uniform, but best practices, those that can be shared. And again, for the rest of us, people like you and I, public education, we have to know more about what is going on around us. We have to know more about how other people are using our data, to what extent they are abusing our data, how we can protect ourselves, how we can protect others around us. And it's not unlike myself, father with children. When my kids went out, it was a question of making sure they were safe. When your kids go onto the computer, how do you provide them with safety? We have safety locks and all the rest, but we don't have safety locks very often for people who are very capable of living a reasonable life and are not children or elderly, but are also vulnerable, such as the people, the corporates who are effectively subject to this cyber attacks that I described. So that's really all that I have to say, maybe far more than I should have. And I'm happy to answer any questions or provide further information if that would be useful, or have a discussion, because I think this is an area of wide open space for, in space I mean, because there's a lot of unregulated activities. So ideas, I think, are the key to the future.
Thanks, Leon, for that excellent presentation there. And we might just open it up to the floor. If people could put their microphones on to ask any questions. And I see Laura has asked a question there. Where does stolen data end up? Is the first question, Leon.
I think it's a very good question, Benjamin. It's a very good question. Sorry, no, Laura. Sorry, Laura. I've got a daughter by the name of Laura. I think that stolen data can end up in all sorts of different places. One is it could simply end up in a database with lots of other stolen data, and that information is abused. If you want to engage in electoral engineering, you collect data and you can then decipher how people would react from their data, how they're likely to react to different kinds of political marketing efforts. That's one example, and that is cumulative. That's the collection of data in mass. Stolen data could be your own personal data. We have that interestingly in the US military. There's a lot of stolen data. There's a lot of revenge porn that takes place, and very often this is individuated. You were jilted, or you have a business colleague who left unhappily. We see this happening quite often, and the result is they have a vendetta, and they use stolen data to exploit, to react, to retaliate. So it can go all the way from conglomerate collections of data that are abused in mass because the data is sold or used to third parties in order to secure benefits such as voting benefits, identifying how people are thinking. It can be sold to marketing companies who want their data for the purpose of identifying how they should market. It can also be collected and sold on an individual basis. You sell my personal data to somebody who will then, who feels that they could advantage themselves by essentially abusing that information. I'll give you a classic example. I do quite a lot of domain name disputes. During the course of my career, I think I've done must be close to 100 for World Intellectual Property. They're all online. You can see them. I'm one of many that do them. They're not particularly skilled, but basically what you do with a domain name, you've got a corporation and I want to take your name. So I will create a name that's very similar to yours and I will essentially cyber squat on your name in order to attract people that would otherwise access your website, you name it, they will access my website thinking they're going to yours and I'll sell them some lookalike product. Or I know somebody else that would love to compete with you, have similar products, simulated products, and they would like to buy it. So it costs me $8 to buy the domain name, the disputed domain name, and I'm selling it for thousands. Or I can persuade you to buy it from me if I intimidate you and I threaten you, and you might buy it yourself to protect your company. Those are examples of cyber squatting, which constitutes abuse, and we have regulations to deal with that.
Thanks, Leon. Benjamin, you had a question for...
Okay, thank you very much for your presentation. I really appreciate your thoughts. I have one question. Since I work in my private part of academic life, if I can say so, I work as a data protection officer in several companies, namely also in health institutions. And in my opinion, since the GDPR came into force in EU, there has been, in my opinion, a big change in perspective of people. Since when I talk to doctors in health institutions, they came to this notion that I have to be aware about personal data. I have to take care of what I'm doing and so on. But on the other hand, I have a question for you. Do you think, and to what extent maybe the GDPR affected on all those issues that you mentioned regarding personal data protection, since the safeguards of the GDPR are set, in my opinion, they are quite high in comparison to the other world. So, often when I'm explaining to students the GDPR, I often say that the GDPR is just like virus. If you want to have a business in EU with EU citizens, you have to be compliant with the GDPR. So it's just like a virus to the whole globe. And I'd like to hear your opinion about this.
Okay. I just want to qualify. Sure. What do you mean by virus? You mean the GDPR will spread, the rules of the GDPR will spread? Is that what you mean by virus? Or?
Yeah, I mean virusly, because since the adoption of GDPR, also other countries adopted similar GDPR legislation.
Yes. Look, I think it's, in a sense, you have a lot of expertise, which puts you in a very significant position to influence change and to understand it. I think you're right. I think a lot of views around the GDPR is it's ahead of its time and that there will be difficulties adapting it because it's high level. A lot of it is policy principle and less application, although the courts in European jurisdictions, EU jurisdictions, are providing an interpretive framework. It's still, in some ways, a high end in the sense of being at a higher level, at a policy and principle level, less standards of application, less rules of application, but that will develop. And most legislation, regulations of that kind start off with high level presentation rules and principles, particularly in codified jurisdictions, unlike the common law that works from the bottom up. The principled codified traditions of civil law makes it comprehensible, understandable, and judges are giving it meaning in practical cases. In terms of it being adopted elsewhere, I think it's the only truly effective, concentrated model globally that can achieve those objectives. So on the one hand, it's the only effective tested and being tested model that's available, which says something. My personal view is that it's also a very well framed and well interpreted document. The problem that I see is the EU is ahead and in many respects ideologically has a high level of commitment to the GDPR, ideologically and politically and economically in a way that is not present globally. I think, for example, the US will not buy into it. There's a very, very strong concern that if you push data protection along the EU line, you will affectionately stifle business. That is a preoccupation. And we see that with the pandemic, strict regulation and business suffers. That's the parallel, certainly in the American jurisprudence. Australians, I think, are a little bit more divided and probably would head the EU way. Singapore, I have my doubts. I think it'll vary as to effectively political ideology. In terms of down the road, I think the EU is taking a broad sweep in that all EU jurisdictions are compliant and are expected to be. That's a big swathe of countries already there. The countries that have already adopted it or simulated comparable models are also growing in number. That gives it a powerful face from which to develop a more concerted, more high standard level of control, of regulation, and also to inculcate, and this is where you fit in, that ideology, that culture within the corporate sector. It's the data effectively regulators within the entities, in the health profession, in the broader corporate section that will ultimately be expected to engage in self-regulation. And it's knowing that there is a broader public structure that will facilitate and enable data controllers within corporate sector and public health sector, among others, to essentially replicate and build their own best practices within that industry, within that sector. Thank you.
Thanks for the questions. Anybody else out there would like to ask Professor Trachman any questions before we move on to the next presentation? That looks good. So thank you very much, Leon. It's close to 10 p.m. your time back there in Sydney, Australia. So you're free to listen into the remainder of this forum, or we will catch up soon, and I'll be back home soon, and we'll go for coffee and look forward to it.
Great. It's been my pleasure. I wish you all well. I follow your history. I've had connections to Ljubljana, and I have friends that are there. I mentioned one that I went to university with in the States. I think you live in a beautiful city. Robert sends me pictures all the time. I think you're very lucky to live in such a beautiful country. Thank you all for your time, and I wish you well in your studies. And I think that you have fascinating careers. If I had my time again, I'd prefer to be born and live past through your era. Thanks again. Appreciate it. Take care.
Hey, thanks, Leon.
Bye now.
Okay. All right, Marco, did you want to go next, or you're happy for me to go?
Maybe because as I wrote to you, I need to leave at about 11:20. So maybe I just jump in now.
Yeah, you jump in now. Yeah, and
not to limit your time, right? Okay. So yeah, it was a wonderful presentation from Professor Trachman. Yeah. So my will be briefer. because also of you know, of the background that is academic is a bit different. I'm not a specialist in data protection, but my recent interest was also in this converging area of artificial intelligence as law, because you know, several legal argumentation experts or scholars, you know, have also engaged in that area. So I'll just spend some time, maybe giving, you know, our, you know, students and colleagues a landscape of the converging area of AI and law that we included, you know, as a special chapter in the book. I'm sorry I haven't, you know, had time for making, you know, PowerPoint presentation. That's the luxury of emeritus professors, you know, because they don't need to teach that much any longer. I'm just kidding here, but you know, so this would be maybe one incentive for our audience to grab a book and read this chapter. So basically, and I'm picking on one of the sentences, what could be from the book, what could be a bridge from Leon's to my presentation, saying AI is a threat to the data protection, while on the other hand, it may offer a number of opportunities to bolster and provide additional protection to personal data. And so that is basically this, you know, two sides of a coin metaphor is what best explain, you know, this double role of AI in law. So also in the book, in this special chapter, are starting with describing the situation, the landscape of AI facilitating law. You know, especially in recent years, and you know, the field is really growing day by day, really rapidly. There has been many attempts, many applications developed, and I kind of sorted out them in two groups, you know. So much more emphasis have been put into the so-called out of court, you know, smart tools, you know, assisting either lawyers or even, you know, potential clients, you know. So you know, by now I'm sure, you know, everybody is aware of legal analytics, of specific analytical tools like, especially in the area of predictive justice, you know, these tools that are able to so to say profile judges and courts in order to predict their decisions, such as Ravel law, etc. I would refer to a book here in which, but it's a bit, you know, it was published in 2018, and that's already outdated, I would say, you know, because many more up-to-date information could be found on the internet. But the book entitled "Rebooting Justice" by Barton and Bibas is about how to use artificial intelligence for actually helping, you know, needy people, you know, in the area of social security and etc. How to decrease lawyers' fees. You know, the book, you know, targeted especially the U.S. legal market, you know, where to some extent it could apply to our area as well. But there's been other, you know, in these other smart applications like weave wars using for getting a divorce, then you are probably aware of ODR, online dispute resolution, smart application used by eBay, PayPal, where the application leads you, online, completely online, to solve a dispute. I'm aware that that's been also used in Europe, especially by some tourist agencies, where you get this, when you book your vacation, for example, and in case, a dispute emerges, the application would lead you with the provider, of that, with the seller, through all these steps in order to resolve the dispute. And this ODR is mostly linked also to ADR. This ODR actually, of course, it's a kind of mediation. It's a kind of mediation that, Benjamin, yes, that's also used for European businesses, and I'm sure it's applied as well in the world. Then there are some consulting tools, of course. I'm sure, like Lexis, this huge American legal database company, they bought software from some starting up, from Stanford. Lexis Answer Card, where you could just, in natural language, you can type in your legal problem, and they would come with a sort of solution, and that's based on AI, application in the background. And so, of course, we already know smart contracts issues and built on blockchain technology. These are some of the applications, smart applications used in the so to say out of court sector, and of course, they also pose threats to data protection as well. So maybe we consent to to giving them some data, but maybe we don't consent to everything, so it's good, in line with the book, with the idea with the book, it was good to know the landscape, that appears in the area. But then, which is also another topic, or the other side of the coin, is the so-called court or judge AI. And there has been, many attempts, although the field hasn't gone that far in comparison with the out of court, so to say, situation. Why? Because it's more, when it comes to court decision making, we want to be more formal, more protective, more certain, so to say, that they're much higher risk. But there's been, several attempts already, and I just read, and this would be interesting for my colleague Robert, being a former prosecutor, like Chinese scientists develop AI prosecutor that can press its own charges. So they came to this solution that a machine is able to identify at least 8 common crimes, such as fraud, gambling, dangerous driving, and picking quarrels. And then they use an AI tool to evaluate evidence and assess how dangerous a suspect is to the public. And that was built and tested by the Shanghai Pudong People's Procurator, the country's largest and busiest district prosecution office. So maybe Robert, some ideas to return to the to the prosecutor office, and they say that the AI prosecutor can file a charge with more than 97% accuracy based on a verbal description of the case, according to the researchers. So we could be, on one hand, we could be happy to hear that, but on the other hand, we could be really frightened, what these applications, of course, can do. But we know that at least in the West, we are a different environment, and we would be much more wary when it comes to this, this invention. But also in the court sector, people already deal with the so-called court or judge AI when it comes to, and there is this idea of online courts, introduced by Professor Richard Susskind from Oxford, who is also the lead advisor of British government on AI and law. He sometimes says, referred to as a guru of AI and law, and that's been already, even in courts. This AI, although it is in when it comes to real automated decision making, there's been already some attempts in, for example, small claims cases in the UK, in the Netherlands. But then I mostly, I expect this area will develop a bit more, but more when it comes to the so-called easy or clear cases, because with unclear or hard cases, it's it's a tricky to use this kind of, but we never know with development. And especially I know that in Chinese courts, they have a special service to check the uniformity of case law by using AI applications, so that could be useful for Slovenia environment where we have like severe problems with the uniformity of case law. Say, I also predict, but I don't see, I don't see in the future a robot judge, to decide, these most demanding cases. I rather see a new profile of a lawyer, who would monitor, at courts, for example, who would monitor, who would maybe revise or something like that, decisions done by these, smart applications. Yeah, and then there is, of course, this area that is maybe more interesting in this book, is how law should regulate AI, and there is a lot of information in the book about personal data issues. Yeah, that's the center, that's the focus of the book. Personal data and privacy. Of course, that's also the issue that Professor Trakman also discussed. That's really important, and of course, there are other legal issues that we need to discuss in relation to AI and law. And of course, there is, when it comes to personal data, there is the GDPR, of course, and then the coming EU regulation on AI, which would also be interesting for us to see. But you know, other issues that are involved are, for example, civil liability when it comes to you know, damage done by, you know, by AI, by smart application. You know, who takes the responsibility? Is it the probably it's the operator or the controller, not the machine itself. There's been decisions already on that, but you know, what kind of liability is to be applied, fraud, or I mean fault or strict liability. I mean, there are also ethical dilemmas that's been already tackled by the EU Commission and also the Council of Europe. You know about that. There are IP law issues. You know, patents and all copyrights, and of course cybersecurity. You know, so there is a lot in this book. And another topic that we haven't included, but is also emerging, the so-called revision of algorithm processes, how, you know, these interdisciplinary teams are to be established in order to revise you know, these algorithms before they're applied, you know. And maybe even, you know, this revision would fit this probably this new profile of a lawyer, being like a reviser of all these applications. You know, these are some of the thoughts that I wanted to add to this discussion. So it was mostly like presenting a landscape of what of, so to say, current state of the art in the area. But you know, I don't want to steal much of your time. I think my colleagues, my students know me already, so it's better to you know, to leave more time for our guests to present their work, and I'll just stop here. And thank you again. So please, Robert, extend my thanks to Professor Trachman as well. But we'll be in touch, of course. Yeah.
Yeah, thank you, Marco, and appreciate that presentation. And just on that, to everyone here, Marco's actually played down, as he normally does, his contribution to the book. It was a little bit more than just doing one chapter. There was a lot more thinking and consultation that we did, and work that we'd done. So you know, you can play it down, I'll play it up, and so thank you for your contribution.
Thanks.
You know, it was great collaboration. So yeah, thanks again. So I'm going to conclude our session today with an extension, really, of what Professor Novak has put forward, and Leon as well. And you know, just on the point of AI in all of this space, it's highly contested at the moment and complicated. And you know, Marco mentioned the point about having a robot as a prosecutor or a judge. When you look at the civil law system and compare that with the common law system, even though the UK is used some of that at a lower level, how that would be used is if you aggregate that to you know, bigger, more complex commercial cases and criminal law cases. When in the common law we have more of a subjective test of the law as opposed to the objective you know, legislative interpretation under the civil law. So it'll be interesting to see how that progresses and how that unfolds going forward. But what I'm going to do is going to give you a presentation on cross-border data flows and its evolution. And this comes out of a project that Leon mentioned and touched on earlier on. that I've been involved with 4 governments, and some of the issues that have come out of that, which is interesting in and of itself. So I'm going to start this by saying that we here in Slovenia and the EU are driven by the GDPR, right? But when you look at it more broadly, and you look at the economic drivers that are driving the new IR4 industrial revolution, you look at what the World Economic Forum have said in this area. They're pushing for open data, the open data concept, and in doing so, the World Bank and the IMF, and some work that I'm finalising at the moment, is all saying that if we open up the data flows, then the GDP economic output to each country and overall at a regional level and international level will be significant. It'll create a lot of new jobs, which there's already those that are interested. There's a shortfall of jobs of people that specialise in cybersecurity, AI, and to a lesser extent the data side of it. But it's opening up in this cross-border data flow. So the question there is, how do you get the balance? You got the GDPR, which we all know has a very high threshold and is used really as the benchmark around the world. All right, it's rights-based. We know that. But the other side of that is balancing that with this open data concept. So how do we do that? So I'll just give you a little bit of background and then we'll feed in and try and answer that question. Well, we all know here that data protection means different things to different industries, government and people around the world. It's a far from settled area of law. The legal concepts and legal norms and principles are far from settled. The notion of privacy itself, which data protection is a tool of privacy, is looked at and interpreted very, very different from country to country to region. And there's no better example than Leon touched on the country of Singapore, and I spend a lot of time there where my wife is. And so for them, the notion of privacy is not there, right? They accept that government will intrude on your life. And the founding father, the late Lee Kuan Yew, said openly that if we don't intrude in and on citizens' lives, Singapore wouldn't be what it is today. It's been influenced significantly by culture, religion, and sovereign needs. And you've only got to go to a country where I do a lot of work with as well, in India, and a fascinating country. When we look and try and understand what privacy means for India as a whole, as a country, and the culture, religion, diversity, even the linguistic diversity influences the perception and understanding of privacy alone, just in that country. So then when you move to the Middle East, it's different again. You go to the African continent and there's slightly subtle nuances there that are different again. And so when you trace the history of the development of data protection, you trace it back to, post-World War II, the notion of privacy in the Declaration, 1948 Declaration on Human Rights. And then really it started to take off in the 1980s with the Oecd Principles in 1981 and the Convention 108, which was implemented about the same time. And then not long after that, you had countries, Australia implemented their privacy laws in 1988. And then and by that stage, member states had already implemented elements of privacy law or data protection law. And then that converged into the Directive 95/46 in 1995. So reconciling this notion that we face today, and this is how rapid it's moved, we've come through a period there where it was really looking at the benchmark of the EU setting the framework for data protection law through the Convention 108, and then following on with the Directive 95. To what we have today. So between 95 and 2022, the shift has been enormous. Back then, you probably had not even a third of the countries around the world that had data protection laws. Today, there's around 150 of the 198 countries. There's still many out there. India and Indonesia are two very good examples that don't have specific data protection laws. They're still developing theirs. Thailand as well haven't implemented theirs. While they look to the EU as their model and use that as a benchmark, it means different things to them. Right, so just on that alone, trying to reconcile this tension between data flows and economic growth with privacy over the internet is a very, very complex area of the law. I've pretty much touched on most of that, but the digital economy is significantly shaping the way we operate online. That's both in business and the private sector, and furthermore, you've got other areas there such as even education. Data flows will transcend between countries and government. And that's the work that I've been undertaking now for the last 12, 18 months. And it looks like I'm going to be working for another government, my home government back in Australia, shortly on a similar work. And mind you, I'm a Slovenian citizen as well. So where did this all start from? I've touched on that. What are the influences now in this space? We've got the UNITAD, which is very important, OECD, which I've mentioned, the International Conference on Data Protection Privacy Commissioners, and the work they do in a policy realm, the International Law Commission and associations and organisations, the WEF, which is pushing this open data concept where no borders or restrictions will inhibit or minimise the flow of data. The G20, which I touch on a little bit of their 2019 communique. The African Union, which is working to consolidate and try and get a level of I call it harmonisation. People are using the word, well, the people will use the word interoperability. I might talk about that a little bit later on if we've got time. APEC, which have rules and set up a framework. Asia Pacific Privacy Authorities. ASEAN are establishing their own rules. Commonwealth of Nations have the Secretariat has model law. However, in all of this and all these international and regional organisations, common denominator comes out of the whole lot. 1, lack of coordination. 2, lack of convergence. 3, lack of harmonisation across the board, right? What I didn't put in there was the EU. Well, we know with the EU, because the member states have, afforded a level of sovereignty to the EU organisation commission, then they're able to harmonise the laws for member states here in the EU, right? But beyond that, it's a highly fragmented area. The OECD principles, which I touched on, they're important when it comes to protection of privacy and even this concept of data flows. Core principles include the following: the collection, limitation, data quality, purpose specification, so it's only going to be used for a specific purpose, use limitation and how that's used and why it will be used, so limit its use, ensuring a high level of security safeguards, openness and being transparent as possible about where people's data is being collected, stored and used, and how it's being used. And individual participation, so the data subject, us being consumers, understand their rights and understand the obligations of particular entities, and holding the system and the framework and people that use our data accountable. Have we got it right? Is the GDPR perfect? We could all probably say no. Will we ever get it right? And will we ever have a high threshold of accountability that enables data flows and economic growth, but at the same time balancing the need for a high threshold of protection? As Leon said, I don't believe we will, and I'm in the same camp as Leon on that point. However, there are ways around this, and the OECD principles are highly relevant, should never be discarded. But what can be done is they can be built upon. Data is now being collected and used, as we've heard, over the internet. By Leon, and we know that most of this, we had Benjamin mention health, but it cuts across every area: agriculture, environment, consumer, customer data, health, education, transport, infrastructure. Transport's huge, national security. I don't want to go down the road of national security, but there's United States established that Act 2019. My guess is, an assumption is, that it didn't go any further because of the election. But when you look at that legislation, it puts it places another layer of threshold protection on our personal data. So it'll be interesting to see how that evolves and how it will evolve. And, the work I'm doing, I just recently had a look at where all the cloud data centers or storage centers are located around the world. And it's interesting that once our data, ends up in cloud, ends up in the system, then, where does it land? So I send it to you from Australia. There's data centers here and in Australia, but there's quite a number in Asia. Does it go via Asia, then the US, and end up in the data center in the EU? Now, the technical people will know that. Legal policy people, I don't believe, are fully across it. The G20 and why that was important, the communique out of there in 2019, because they said that, similar to what the World Economic Forum are pushing forward, is to promote this international policy discussion around cross-border data flow. That is, open it up, right? The benefits of doing so will be greater in innovation, in science, education, government. Knowledge generates higher productivity. So there'll be a bottom line GDP benefit of that. However, in all of that, they still recognise that there are challenges related to data protection, intellectual property and privacy. And so striking that balance is going to be, significantly tested. And this is a good a good table to start with, right? So why have I picked these countries here? Is because it's a good snapshot at this point in time, 2022, 2021, of the different models of data protection. So we know the EU's, it's rights-based. The UK, even though they're out, they've still adopted, by and large, they have retained the GDPR to date. They are looking at legislative amendments. But I know for a fact, working with them, that they don't want to move too far away from the recent adequacy decision that they've got under the GDPR framework. Singapore adopted many of the principles of the GDPR, but however, I would argue that it's more business friendly and far from rights-based, as I've already explained. They view privacy in a very, very different way to what we do here. United States would be described as a consumer protection-based framework rather than a trade framework, and they place economy ahead of, pretty much at the forefront, and that's their number one pillar, and it has been for many, many decades. And we see that, and those of you who follow this area know that the recent Privacy Shield has been challenged, and so the 2 iterations of that were found to be invalid under the European Court of Human Rights, I think it was, or the European courts anyway. And so, that flow of data now has been inhibited and restricted in some ways. Having said that, at the local level in the US, so there's some of the states have adopted privacy legislation, which all but mirror the GDPR. So it's an interesting characteristic. At the national level, it's highly fragmented, consumer-based, trade-based, but at a state level, they're moving more towards a rights-based model. China is an interesting one. Some scholars call it data laws or cybersecurity laws by sovereignty, and I would agree with that. It's certainly focused on their own sovereign needs. They up until late last year, they had not, they view privacy again very, very differently to how we do in the Western world. That doesn't mean to say that they don't have privacy enshrined in their legislation or their legislative frameworks. They do, but they treat it very differently. So prior to 2021, it was more their own characteristics, organisational based, where we in the other countries that I've mentioned regulate the user. They've predominantly regulated the organisation. That has subtly changed, believe it or not, with the Personal Information Protection Law in 2021. That is now extended its reach, and it's fair to say that it's come even more closer to the EU framework than many of us would have thought of, and thought that they would shift in that direction. So it was. It's an interesting move, and more analysis has to be undertaken there. And then, of course, where I come from, Australia, well, the best way to summarise Australia's model is it's a combination of all of the above, but it's moving more in the direction of the US-based consumer model. So I've touched on the models. I won't keep you here for too much longer. They're the core principles that you're probably well aware of that are found out of the OECD framework, more importantly, the GDPR. How does that, what does that look like? This is what it looks like, right? So the X is GDPR up the top there. You can see when you get to Singapore, the number of zeros. Come down to the United States, similar approach. China, and that was done prior to this analysis was done prior to the implementation of the laws last year. So their cybersecurity approach was, there's a lot more zeros there. And then Australia's approach, believe it or not, still there's a couple of zeros there. So all in all, what does it tell us? It's a highly fragmented space. And this is in conclusion, this has just come out of some work that I've done. So I come from government and regulatory reform over a long period of time. So I understand the machinery of government and how it operates and what they look for. So I developed this risk-based model of it's a theory of action to describe what needs to happen in order to achieve the open data concept pushed by the WEF, but at the same time retain a level of threshold protection that the community expect. So you start on the left-hand side there, policy, what's it mean? Evidence-basedness, some of you may or may not have heard about this, but what does it mean? It means understand technology, AI, and the security, so cyber security. Because increasingly it's holistic anyway, yet they're separate areas of law. Risk identification and management. Government sets the minimum standard, and Leon pointed that out before, that increasingly it's no different to many other sectors, right? Airline industry is a good one. Primary production, food processing and production is another one, where government sets the minimum standard, and industry actually evolve that and use that and take it forward, and create their own standards, because each individual sector is slightly different. Values, we don't really need to touch on them, but a couple of broad-based ones in this increasingly higher contested world that we live in, and we've only got to watch the news to see what's going on there, and the impact to the current rules-based system and rule of law. Ethics, trust, accountability, transparency, secure, comparable, reliability, and accessibility are all high-level policy principles that need to be achieved in order to get, I would argue, more legal convergence and harmonisation, right, rather than interoperability, and I'll conclude on that point in a minute. And then the outcomes, so you get transporter adequacy and open data. In the regulation at the international, regional level and national level, I've highlighted what those areas are there. But down below there, where I'm pointing to are the tools. There's a number of tools to achieve that. And then we look at data flows, what it is, and then the security around that, which is, a high, there's a lot of public pressure to do that. Interoperability, I'll talk more about that and what that means. Governments around the world, here in the EU is saying they push that. Is it right for the time? I would argue it's time to shift that thinking. And that's only my analysis. Data processing. What's the processing mean? Consent. Does everyone understand what consent means? I would say that's an increasingly contested area. Why? Because you get all this consent and then they take it away with all these exceptions, right? And there's been numerous studies done on that. If I give you my data, I consent to you using it, but does that then allow you to pass it on to a third person, fourth person, 10th person? Have I still consented to the 10th person or organisation that's using my data. Do I understand that? Comes back to that education, communication, etc. And then legitimate restrictions. What are they? Data localisation, which is based really on political needs, storage, government, private sector, extraterritorial reach. And I'll conclude on this point on interoperability, because this is coming out in a book I'm concluding in a little while over the next few weeks. Is this notion of interoperability, and I argue that the time has come whereby interoperability has been the first step, right? And it's been a default usage of interoperability because that's what the technologists have used in order for IBM to talk to Microsoft, to talk to Oracle, right? And to talk to each other, and Apple, and all the different systems and models and frameworks out there, that it's been applied and used effectively by the tech industry. However, and what's happened is they've transposed that across to then apply it in policy and law, and more so the law, right? And what we're seeing in the analysis of when you undertake the comparative analysis of the legal frameworks here is that, particularly when we talk about data adequacy, right, that the gaps in the data adequacy decisions alone, except take away or put aside the UK decision because they fully implemented the GDPR anyway. So when you have a look at the adequacy decisions, you've got to come down to understand exactly what adequacy means. Does adequacy mean that the protection, the protections that are afforded by the GDPR and the requirement to meet those exceptions is pushed for in the GDPR, but this notion of adequacy is just that, it's adequate. Right? It's not a reflection of any legal convergence. It's not it's in part a reflection that you've got adequate standards, but it doesn't mean to say that a third country will fully meet those standards. Right? So if we're true to the system of what GDPR wants to achieve, right, and more generally, to ensure that data flows can operate effectively, and then those threshold protections are retained and built upon, I believe we need to move forward with this notion of interoperability and data adequacy and take it to the next level. And I'll conclude on that. Any questions? No?
You can also write questions in the chat if you want.
Yeah, so certainly you can put a question in the chat. It might be quicker if we do it over the microphone.
I think no questions for now.
Okay, that's okay. Well, that's a long session. I hope it was informative. Thank you. We've got one more on, I believe, next week on Untitled law.
23rd, I believe.
Sorry?
23rd?
Yeah.
Yeah. I think in Wednesday.
Yeah.
The last one.
That's the last one, yeah. So feel free to come along to that one. We'll talk about Untitled law and international commercial law. I've got another professor friend of mine from Australia attending that one, Bruno Zeller. So thank you for your time. Have a good weekend, and good luck in your studies and your profession. Thank you.
Thank you, Professor.